Hi, welcome back to Finally Revealed. In this video, I want to talk again about Fair Debt Collection Practices Act and what the debt collector, what information they have to give you by law within 5 days of the initial contact with you. Now this applies if this information is not contained in the initial contact with you, and it applies whether the initial contact is in writing or by telephone or by other means, maybe electronic or in person. You don't hear about it in person very often, but it's possible. So these are the things that have to be communicated to you within 5 days of the initial communication, unless they already gave it to you in the initial communication or unless you've paid the debt. All right? They are, number one, written. It has to be in writing. It has to tell you the amount of the debt. It has to tell you the name of the creditor, who they say you owe. They need to have a statement in there that the debt will be presumed valid, both as to the amount and that you are the party that owes it if it is not disputed by you in writing within 30 days from your receipt of this communication. And if you do dispute it, then within 30 days they will communicate to you proof of the debt, either by a copy if it's some type of a contract that you signed or a charge that was made at a store, or some type of other written evidence of it that will also show you who the creditor is. And this all will be verified. And also, if they are not the original creditor, they will give you in writing the identity of the original creditor, including their name and address. Now, if you do nothing when you get this notice that gives you this information, while it says in there that it is presumed valid as to the amount and that you owe it, remember, this is a credit card company usually, or some other collection agency. This is before you are sued. So while they can say, if you don't contact us and tell us you don't owe this, or it's the wrong amount or something like that, they're going to presume it is valid. That is for their purposes of contacting you. That is not something that then, if you are later sued, prevents you from saying, hey, this is not my debt, this is not the right amount, etc. And primarily that's because what if they send it to an address that you're not at anymore and you don't live there, and they're sending, if you move into an apartment and you get mail for the people who used to live there, you'll usually write not at this address or return to sender, but you might throw it away. So by the same token, if it's sent to you and you don't live there anymore, while they can say we sent it to the last known address, they didn't respond, we presume it's valid, so we're going to continue making our contacts. If they then sue you, they have to serve you. If you're not at this address, obviously, then this assertion that you didn't dispute it will not hold up in court. So it's only with regard to the it's only with regard to the collection agency that this would not be considered disputed. And then finally, if you do write back to them and say, I dispute this, etc., and they're going to have to get information on the creditor or the debt and proof for you during that 30-day period, and until they provide that additional information, they can't contact you anymore. I hope this was helpful to you. If you have any questions, leave them below. Also leave any comments if you've had any of this experience with this that might help someone else. Share this video with someone who might need it. And subscribe to see the other videos, and come back and see me next time. Thanks for watching.